Thank you for your interest in this review. I was the secretary to the review, which meant that I was the lead author and officer for the review's work. The review made its recommendations in December 2019. The review was independent. This presentation is about the work that the independent review team did, including the recommendations that we made and the views which we formed as a team. Scottish Government asked for this independent review, and the review made recommendations which we believe are right for autistic people as citizens of Scotland. However, it is for Scottish Government to decide whether it will act on some or all of our recommendations. The review was hosted by the Mental Welfare Commission for Scotland, which gave us an office space and corporate services. I am currently working there on different work, and of course, the views of the Mental Welfare Commission are not necessarily the same as the views of the Independent Review's executive team. This was a review of mental health law. When it was created, Scotland's mental health law was world leading in relation to human rights. Since then, there have been developments in case law from the European Court of Human Rights, which have clarified how Scotland should implement the European Convention on Human Rights. Also, the United Nations Convention on the Rights of Persons with Disabilities was created and was ratified by the United Kingdom after our current mental health law was created. In essence, we think that the positive approach of the Convention on the Rights of Persons with Disabilities can be used to enhance the rights in the European Convention on Human Rights. This presentation is in two parts. Part 1 is less technical and might be of interest to anyone. Part 2 is a bit more technical and is intended for anyone who is particularly interested in the law and human rights. The review ran during 2018 and 2019. It was chaired by Andrew Rome. Andrew, Catherine Evans and I were the review's executive team. We had many advisors, however, all decisions were made only by the executive team to make sure that the review remained independent. The review considered whether autism and learning disability should continue to be defined as mental disorders in law. I apologise for any offence from this term, which I have to use to accurately describe the current law. The review addressed the challenges of complying with the United Nations Convention on the Rights of Persons with Disabilities, the CRPD, and mental health law in Scotland. The review made recommendations which could possibly lead to the paradigm shift that this convention requires. A paradigm shift is a major change in basic concepts and in how things are done. The review also created a new approach to governance and engagement in the review that fully involved autistic people and people with learning disability. This was to comply with the CRPD's requirements on how law should be reformed. Two laws were relevant to the review. The Mental Health Care and Treatment Scotland Act 2003, which I will call the Mental Health Act, and the Criminal Procedure Scotland Act 1995 for offenders with what the law currently calls mental disorder. I'll call this the Criminal Procedure Act. In relation to these laws, some autistic people may need care and treatment for mental illness or personality disorder. Some autistic people have learning disability. Under these laws, some autistic people may meet criteria for compulsory care and treatment as an autistic person with mental illness, personality disorder, or learning disability. Very rarely, a person can meet criteria for compulsory care and treatment as an autistic person who does not have mental illness, personality disorder, or learning disability. The final report and other reports from the review are currently available through www.irmha.scot. That web link will end soon, but the website has been recorded in the web archive of the National Records of Scotland. Scotland has many commitments in international human rights law. For example, the United Kingdom continues to accept the European Convention on Human Rights and several United Nations human rights conventions. Scotland's law has to change when new commitments are made and sometimes when new judgments are made. All of Scotland's laws and everything that public authorities do must comply with the European Convention on Human Rights. The Convention on the Rights of Persons with Disabilities, the CRPD, makes it clear that people with disabilities should enjoy their rights on the same basis as everyone else. The rights of people with disabilities can be limited on the same basis as for other people. In this convention, how decisions are made is very important. All decision-making has to make sure that an autistic person's rights, will and preferences are respected on the same basis as other people's rights, will and preferences. When people's human rights are limited, these limits must be done in a proportionate way. As for everything in this convention, in practice, limits to rights must be used equally for all people, and limits must not discriminate against people with disabilities in any way. Many autistic people do not see themselves as having a disability. In our final report, we recommended that autistic people should be able to describe themselves however they wish, and that professionals should accept this. However, for autistic people to have full access to their human rights in law, the law has to recognise autism as a disability. The CRPD requires important changes to be made in how law and services define disability. The CRPD says that we need to understand disability as something that happens when people with impairments meet barriers in attitudes and in their environment. We need to see all people as equal citizens who have equal standing before the law, and we must support all people to make full use of their rights. Scottish Government set the remit for this review. That remit included the operation of the Mental Health Act. Are autistic people and people with learning disability well served by that law? To measure this, we asked people about their experiences of Scotland's mental health law. Then we thought about how people's human rights were affected by the law. We also had to look at the role of psychologists in mental health law, the definition of mental disorder in the Mental Health Act in relation to learning disability and autism, the criminal justice system and its interaction with mental health law, and the use of psychotropic medication, that is, current prescribing practices in medications that are used for mental illness. Those medications are sometimes used also for behaviour management. Here's how we did the review. The review took a human rights-based approach. This means that in everything we did, we thought about human rights. We worked to promote and protect people's human rights in how we did the review, as well as in what we recommended. For example, we prioritised people who would have found it most difficult to take part in the review. We had accessible materials for every stage of the review. We included people with limited communication skills and people who were detained in wards. Stage 1 of the review found that even when good care is provided, the Mental Health Act does not always promote and protect the human rights of these groups of people effectively. This told us that there is a need for the law to change. Stage 2 gave suggestions for future law. We met with many organisations in this stage. We also spoke with experts from around the UK and Ireland and from 4 other countries. Stage 3 tested a set of proposals for law reform. We took everything that we had heard and we created ideas on how the law could better promote and protect human rights in future. Then we asked people what they thought of these ideas. Then we wrote our final report and recommendations. We await Scottish Government's response to our recommendations. We spent a lot of time developing the processes for the review. We thought that we were successful overall in making a very complicated and technical review of law accessible for people with a range of communication styles. This took a lot of time, consideration and effort from the review team, working with our advisors. At times we made choices and did things that were different from what people expected. There's a report that tells you about what we did. It's called How We Did the Review, and you can find it on the review's website, currently at www.irmha.scot. In the report, we describe the things that went well and things that could be improved upon. We hope that this report would be useful for other people who may wish to carry out reviews in future. The Scottish Human Rights Commission, SHRC, acknowledged how thoroughly and carefully the review team had engaged with the requirements of the human rights framework and how we had used it to come up with concrete and practical proposals for changes to law and to bring them to life. SHRC also said that we led the way in engaging with all aspects of a human rights-based approach, in particular that people with lived experience of autism or learning disability were involved in all parts of the review, and that great efforts were made to make complicated ideas accessible to all. SHRC thought that the review's work will be informative for other current work. Scotland is moving to incorporate economic, social and cultural rights directly into Scots law, such as the right to the highest attainable standard of physical and mental health. And there's a current review of Scottish mental health law led by John Scott QC, and an independent review into the delivery of forensic mental health services led by Derek Barrett. Here are some of the recommendations from the review. We recommended that autism and learning disability are removed from the definition of mental disorder in the Mental Health Act. We did recommend that autism be defined in law. We recommended that the law states that an autistic person is a person who has a professional diagnosis of autism. However, it will be important that autism is defined in a law which sets out the right context for understanding autism. We also recommended that a new law is created to promote, protect and fulfil positive rights. A positive right is an obligation on the state to provide some benefit to the person who holds that right. A new law for autistic people should serve to ensure that services are available, appropriate, accessible and of good quality to meet the right to health. Along with other reforms in law, this new law should ensure that all relevant human rights are promoted and protected for all people. We recommended that changes in law and improvements in services are put in place before autism and learning disability are removed from the definition of mental disorder in the Mental Health Act, and that a date should be set for this. The review found evidence of human rights issues in the context of Scotland's current Mental Health Act, which have a worse impact on autistic people or people with learning disability than on other groups of people. Positive rights come with positive duties which oblige the state to take action. So, we recommended that in the new law there should be duties on public services to make appropriate services, environments and professionals available for people with learning disability and autistic people. We recommended that Scotland works towards law that removes discrimination in detention and compulsory treatment on the basis of disability. This is work that could be developed through the current Scottish Mental Health Law Review. If you would like to hear more, I will give a lot more detail on our recommendations in the second half of this presentation. The review had many sources of evidence from people with lived experience and from professional sources. We gave equal weight to evidence from this range of sources. Just to give an example of how some evidence contributed to the review, I will talk briefly about how some concerns identified through the Mental Welfare Commission's work for autistic people may be addressed through some of the independent review's recommendations. If this is of interest to you, you may also wish to see the presentation which that Commission are making on their work as part of this conference. On restraint, the independent review recommended that the law should make clear that detention, restraint and seclusion are not treatment, and that statutory guidance should make clear that these can cause trauma for children and adults. We said that health and social care services should develop approaches that reduce the use of restraint and seclusion with autistic people, and that it's important to involve education services also in these developments to share learning in both directions. We also said that detention, restraint and seclusion all risk serious harm to human rights and must be monitored effectively. We recommended separate authorisation for different aspects of deprivation of liberty: detention, use of restraint or seclusion. We also recommended that all use of detention, restraint or seclusion and any other limits to liberty should be monitored consistently for autistic people across public services. On antipsychotic medication, we cited the Mental Welfare Commission's Autism Themed Visit Report, which found that of 54 autistic people with complex care needs who were part of this review, 26 people were being prescribed with antipsychotic medication for behaviour perceived as challenging. The Commission was very concerned by the scale of use of these medications. We recommended that decisions about using psychotropic medications should usually be made by autistic people using support for decision making. When professionals may have to make decisions about the use of psychotropic medication, these decisions should be made in the context of human rights. The medications should only be used without consent if this is demonstrated to be necessary and proportionate through a human rights assessment. We also recommended a clinical review of prescribing practice in psychotropic medication to be led by pharmacy or public health and involving these specialisms in addition to psychiatry. The review should actively involve people with lived experience, including their representative organisations. Delayed discharge can happen when people spend too long in hospital because the right support is not available for them in the community. We recommended that Scots law should recognise the right to independent living of autistic people. We recommended that Scotland should invest in more community-based professionals and support. This is needed so that people can remain in the community or can move back to the community from hospital as soon as possible. We recommended duties on health and social care partnerships to provide access to specially designed places other than the hospital for pre-emergency situations. We called these safe places. We also recommended duties on health and social care partnerships to provide community-based professionals with specialist understanding who work across all settings as required, including home and hospital, and to provide community-based individual accommodation for longer-term crisis support, including crisis prevention. We recommended new powers for the Mental Health Tribunal for Scotland. With these powers, the Tribunal could compel public bodies to provide services that are required for decisions to be proportionate in relation to human rights. This could include requirements to end delayed discharge by making provision for a person in the community. Part 2 is the more technical part of the presentation. A lot has changed since Scotland's previous review of mental health law, the Millen Review, which reported in 2001. Scotland's human rights commitments have changed substantially since then. The UK government ratified the United Nations Convention on the Rights of Persons with Disabilities in 2009. The Scottish Parliament decided in 2016 to implement this convention in full. This is very challenging, particularly in the context of mental health law. The review's report may be the first document to offer a set of practicable solutions for CRPD implementation in this context. One key to implementation is the work of UK legal experts in the Essex Autonomy Project, many of whom contributed to this review. In essence, Scotland is bound to implement the Convention. The interpretations and observations of the UN's Committee on the Rights of Persons with Disabilities must be taken seriously, but are not binding. This approach offers a way through some very contentious issues. More generally, several Commonwealth countries have been working to resolve the question of where learning disabilities should sit in law in relation to mental health law in particular. The European Convention on Human Rights has not changed since Scotland's last review of mental health law. However, there have been many relevant judgments from the European Court of Human Rights since then. Some of these judgments will have significant implications for how Scotland's mental health law should be interpreted and reformed. I'll now say a bit about the recommendations that I mentioned earlier. If you would like to see a list of all recommendations, you can find that in section 10 of the final report. We recommended that autism and learning disability are removed from the definition of mental disorder in the Mental Health Act. As I said earlier, we recommended that autism should be defined in a new law. This is a complex recommendation. We recommended that in practice, the law would enable autistic persons with learning disability, and unpaid carers to use whatever words they want to use to describe the person. Professionals would use people's preferred words when they interact with people who have lived experience. Professionals would also use professional definitions of autism and of learning disability. They would do this when communicating with public services, legal services, and professionals. The law would require professionals to understand disability as resulting from the interactions between persons with impairments and attitudinal and environmental barriers that hinder their full and effective participation in society on an equal basis with others. This would help to meet the requirements of the CRPD within Scots law to incorporate the human rights model of disability, which includes the understanding of disability that I've just described. However, the European Convention on Human Rights requires Scots law to allow for the possibility of detention and compulsory treatment for the protection of human rights. In general, this will require a professional to confirm that the person has a medical diagnosis. We recommended that a new law is created to promote, protect and fulfil positive rights. And we recommended that changes in law and improvements in services are put in place before autism is removed from the Mental Health Act. A date should be set for this. The review's evidence showed that the law was not adequately protecting the rights of autistic people and that there have been specific impacts on their human rights. Autistic people have the same rights as other people, but fulfilling their rights requires access to services that are designed to meet the needs of autistic people. A new law would protect and promote rights in areas of discrimination that autistic people experience more than other groups of people. The evidence from stage 1 of the review told us that autistic people have experienced indirect discrimination under Scotland's Mental Health Act. Indirect discrimination happens when a law or policy is applied in the same way to everyone, but disadvantages a group of people who share a characteristic that is protected by law. We also heard a few examples of direct discrimination, which happens when a person is treated worse than other people because they have a characteristic that is protected by law. This happened when people were excluded from services specifically because of their autism. For a new law to be effective, the law should promote and protect rights to support care and treatment for all autistic people, not just people whose rights are limited in some way. The new law should promote and protect the broad range of rights that relate to mental health. This includes rights to support, care and treatment that meet the needs of autistic people. The law should give duties to provide what people require in ways that allow people to choose to have access to what they need in their own communities and in the same locations as other people. We recommended that Scotland works towards law that removes discrimination in detention and compulsory treatment on the basis of disability. We recommended reform of the law towards law for mental health. The optimal change in law would be towards law that applies equally to all persons. In our report, we suggested ways in which we can move towards such law. In the context of the European Convention on Human Rights, it may not be possible to fully satisfy the requirements of that convention and the CRPD in some respects. In relation to comments from the Committee on the Rights of Persons with Disabilities, but compliance with the convention should be possible, and major change is possible, and is required by the CRPD for Scotland to comply with the CRPD in ways that are compatible with the European Convention. We think that many of the changes in law that we recommended could promote and protect the human rights and mental health of other people, not just autistic people and people who have learning disability. For example, we have recommended human rights assessments as part of a system in law. That system would make it possible to limit a person's rights only when this is shown to be a proportionate decision that respects the person's rights, will and preferences. The Scots review of mental health and incapacity law has begun its work. We wrote that it may be for that review to decide what recommendations, if any, would give similar benefit to the human rights of autistic people, people with learning disability, and other people who are currently defined as having a mental disorder, such as mental illness or personality disorder in our current law. However, we did think that all of our recommendations should be made in law for autistic people and for learning disability by a defined date. Disability neutral law is law which applies equally to everyone. According to the United Nations, for autistic people to have equality before the law in Scotland, we need to move towards disability neutral law. At present, Scotland's mental health law only applies to people who have what the law calls mental disorder. In the review's final report, we discussed the concept of law for mental health and recommended that the law allows professionals to support people who are experiencing serious adverse effects on their human rights in a way that does not discriminate. So the law may need to change towards ending discrimination on the basis of disability. In this context, it may be important to talk about law for mental health instead of mental health law. For example, for Scotland to comply with duties in international human rights law, our law must be set up to ensure that autistic people can get access to the support, care and treatment that they need to be mentally healthy through choice and in their own communities. Our current mental health law does not enforce the protection and promotion of positive rights that are required to achieve all of this. Law reform could also include a move away from mental health law to law that applies to many groups of people who, for example, experience serious adverse effects on their human rights. One way to create disability neutral law might be to combine public health law with mental health law, but the independent review team felt that it was out with the scope of our work to develop ideas on that. This will be complex work, and it may actually be easier to achieve full compliance with the CRPD in that respect in countries that are not party to the European Convention on Human Rights. All of Scotland's laws must comply with that convention, which may put some limit on how far Scotland's approach can go. A potential way to create disability neutral law was brought to our attention in this review through work from Canada by Bach and Kersner, who use a concept of serious adverse effects as a basis on which to develop disability neutral criteria to allow for state intervention on an equal basis across a wide range of matters. The Republic of Ireland has drawn in some aspects of the same work to develop its new law and system for decision support. We spoke with Michael Bach and with the Republic's Mental Health Commission on this during the review. Applying this concept would mean that limits to human rights would be made so as to limit serious adverse effects on other human rights. In testing whether these limits are necessary and proportionate, we could examine the risk to human rights for the person, risk to human rights of people who have personal relationships with that person, and risk to members of the public. When we talk about risk to human rights, we mean actual serious adverse effects on people's rights which have happened or which are clearly about to happen. This includes serious risk to all relevant rights, including the right to independent living, for example, not only the right to life or the right to health. Under the European Convention on Human Rights at present, it would be possible to use this concept, but we could only apply it to groups of people whom the European Convention says can be detained and have their rights limited for civil reasons. We recommended introducing a human rights-based system for all decision-making, including human rights assessment to help ensure human rights are promoted and protected. The system should support professionals to demonstrate reasonable decisions and to demonstrate actions that are compatible with human rights. We made recommendations for several parts of this system in the final report, in sections 3, 6 and 7 of the report. We recommended the right to challenge any professional decision that does not respect a person's will and preferences, and which may not be proportionate for their human rights. we recommended that mental health law should introduce human rights assessments. The current Mental Health Act does not give a clear way for professionals to make and to show that they have made proportionate decisions in terms of human rights. We think that the law should give professionals an approach which requires and enables them to make decisions and demonstrate decisions that are clearly necessary and proportionate. This concept of human rights assessment is based on ideas from the Essex Autonomy Project's 3 jurisdictions report. Human rights assessments would always be led by the person's will and preferences in the context of their rights. This does not mean that the person's will and preferences would necessarily always be given full effect. However, human rights assessments would help to ensure that there is special regard for the person's rights, will and preferences, a concept explained in the 3 jurisdictions report and which we discussed in our report. Assessments would compare the possible benefits of a decision against the possible limits to the person's human rights from that decision. Serious limits to human rights should be rare. These limits on a person's human rights would only be allowed if there would be very significant benefits to the person's human rights overall. Relevant human rights would be clearly identified and would be considered individually. Of course, for any individual, detention, compulsory treatment, or other limits on rights could cause harm, including trauma. The person's rights may be harmed overall. We recommended a presumption in law in relation to all decisions about limits on rights. The presumption is that limits on rights cause harm. This presumption would have to be overcome with evidence that overall benefit to the person's rights is probable. In practice, human rights would be used clearly in all professional decisions, not only in circumstances where rights may be limited as a result of an assessment. We recommended that human rights assessments would be used as a basis for decisions at mental health tribunals and as a basis for planning for support, care and treatment. Human rights assessment would always have positive aims overall. Those aims would be stated in terms of positive rights, which require duty holders to act to fulfil those rights. This should help to make sure that decisions which limit rights are proportionate and reciprocal. The intended effect of the human rights assessment should be to maximise the person's opportunities to exercise their legal agency, that is, their rights and duties, in relation to positive rights such as rights to independent living, private and family life, education, employment, and freedom of expression, for example. In the context of criminal justice, there will be additional limits to the extent to which the person's own will and preference can be given effect. However, the person's rights, will and preferences are still relevant in the context of offences, as are the rights of people who are offended against. To be non-discriminatory, human rights assessments would have to be made available and used in at least some situations where there is no intention of limiting the person's rights. For example, a person with disability may currently have their rights protected and promoted in the context of a secondary school. A human rights assessment might be offered to ensure that the person's rights would be promoted, protected and fulfilled after leaving school. Also, to be non-discriminatory, human rights assessments would have to be made available to persons who do not have a disability in relevant situations. For example, human rights assessments are currently available for some individuals who have immigrated to the UK and who have no recourse to public funds. The point is that the approach must not be used only to limit rights or only for people with disability. If that happens, discrimination happens because the approach would be done to people with disability. The Convention on the Rights of Persons with Disabilities requires Scottish Government and public authorities to respect the rights, will and preferences of autistic people. In the final report, we recommended a new model for professional roles in making decisions with and for autistic people. The current Mental Health Act is based on a medical model of disability. It has a strong focus on medication, hospital and medical leadership. All of these are important. However, a much stronger social and environmental focus is needed as part of a strong focus on human rights. The CRPD requires a paradigm shift, a major change in perspective in how we understand disability. For this to happen, we will need a new model of professional roles in decision making. This is needed to bring about new approaches that reduce the disability which autistic people experience through social and environmental barriers. We recommended a new model for sharing responsibilities amongst professionals. We recommend that new roles should be fully defined with professionals, legal experts and people with lived experience and put in law. For example, some social workers would develop expertise in autism, learning disability and human rights. They would carry out human rights assessments and would be known as human rights officers when doing this. We recommended a rebuttable presumption that all professionals will work to enact a person's will and preferences in the context of human rights. I will explain what this means. The CRPD requires us to focus on enabling people to make their own decisions and to influence decisions. This is about giving autistic people equal recognition before the law, and we are to do this in part by offering support to people. We would also need to change the law, putting into law some aspects that Scottish and UK legal experts have developed in the 3 jurisdictions report, which I mentioned earlier. Those approaches include the rebuttable presumption that the role of professionals and other decision makers is to give effect to the person's will and preferences. This would be a fundamental change. It would no longer be the professional's role to form a view about what would be in a person's best interests and then to work to bring that about. Instead, the professional would begin by working to understand what the person would want for themselves. For those autistic people with learning disability who do not communicate through speech, independent advocates would work to form a best interpretation of what the person would want for themselves, working also with people who understand those individuals' communication well. In situations where professionals had to make a decision to protect human rights, the person's will and preferences would be considered in the context of their human rights and any relevant human rights of other people. We also recommended that independent advocacy should be offered on an opt-out basis to autistic people. There is an existing right of access to independent in Scotland's Mental Health Act, which we understood should apply to all autistic people. Such access is not available to all autistic people in practice. However, for Scotland to meet its duties and respect the rights, will and preferences of autistic people, full access to independent advocacy would be required. We also made recommendations aimed at strengthening carers' rights whilst maintaining focus on the rights of the individual. We recommended that the rights of unpaid carers should be considered in human rights assessments. We thought that a human rights-based approach for autistic people will only work well if it also protects and promotes the human rights of unpaid carers. The rights of carers are often affected by the actions and decisions of public services and the legal system. We recommended that in developing any future law in this area, there should be an emphasis on the importance of the carer's role in the context of the carer's own human rights. And as for professionals, we recommended that future roles for unpaid carers and decisions for autistic people should be focused on implementing the person's will and preferences in the context of the person's rights. All professional and legal decisions that affect autistic people, people with learning disability and unpaid carers should demonstrate respect for all relevant rights, and this includes rights to privacy and family life. We recommended that there be duties in law on NHS boards, health and social care partnerships, and local authorities to provide services, environments and professionals with specialist understanding for autistic people. We wrote that there is an immediate need to provide environments and services that support the mental health of autistic people. The European Court of Human Rights clarified this in relation to people who are detained in its recent judgment on Rumen versus Belgium. Also, the Joint Committee on Human Rights in the UK Parliament has concluded that inappropriate treatment in hospitals for autistic people and people with learning disability can give rise to serious breaches of human rights. And public authorities must demonstrate that they meet their existing duties under the Equality Act 2010. We saw some evidence that this is not always happening consistently. So, we recommended that there should be new duties in law on health and social care partnerships, NHS boards and local authorities to provide access to health and social care professionals who have experience and understanding of how to support autistic people. We wrote that in practice, these public authorities should involve autistic people's organisations and autistic people in general in the planning, development and governance of services for autistic people. Autistic people's organisations are organisations run by and for autistic people, rather than organisations run by neurotypical professionals, for example. We also recommended that autistic people's organisations should be involved in processes that determine which professionals have experience and understanding of how to support autistic people. This review looked at the criminal justice system and its interaction with mental health law for autistic people. In sections 8 and 9 of the final report, we recommended changes to make the criminal justice system fairer for autistic people. We made recommendations on how Scotland could introduce the disability model to the criminal justice system to ensure fair access to trials, fairness and responsibility for offences, fair punishment and fair access to support and treatment for offenders. First, in section 8, we discussed how the human rights model of disability could be applied for autistic people within the criminal justice system. Here are some examples of what we recommended. For fair trials, a person would be offered all necessary supports and adjustments in order to be able to stand trial. This could include supporters called registered intermediaries for anyone with communication difficulties. Even with all possible supports, it may not be possible for some accused autistic persons to take part in the prosecution or trial process in a way which would make that process fair. We recommended that, as at present, those autistic people would not have to stand trial, and an alternative to trial called an examination of facts would take place. For fairness and responsibility, a defence of disability could be made instead of the current defence of mental disorder, which would be to indicate that the person did not have criminal intent. If the defence of disability was accepted in full, the person would not be held responsible and would not be punished. If this defence was accepted for limitation of responsibility and the person was held partially responsible, the person would receive punishment and this could be reduced due to the limited responsibility. Whereas the current defence of mental disorder focuses on impairment, a defence of disability would also consider social and environmental disabling factors such as inadequate support. Within the current Scottish criminal justice system, disability can already be taken into account in decisions about sentencing in terms of the impact of the sentence on the individual in the context of their disability. With the human rights model of disability, the impact of a sentence should be no greater for someone with a disability than for an offender without disability. When a person needs support to stop offending, or support, care or treatment for mental illness, for example, this could be authorised and monitored by the Mental Health Tribunal for Scotland. At present, as for the other offenders, some autistic offenders may spend many years in forensic hospitals following their offences, and some of those offenders will have understood that what they did was wrong. However, detention in hospital is not recognised as punishment, and detention in hospital may continue indefinitely. This contrasts with the experience of autistic offenders who are sent to prison, and the experience of offenders in general, who will usually be given fixed term sentences with their custody clearly identified as punishment. We recommended that autistic offenders would not be detained for longer than an offender without disability would be detained for an equivalent offence, and its duties and enforcement powers would exist in law to ensure that support is made available during detention and within the community. Section 9 of the final report made recommendations on how Scotland could make support and places of detention appropriate for autistic offenders. We wrote that autistic offenders should be able to receive the support, care and treatment that they need wherever they are. In the final report, we discussed habilitation. Habilitation is a process of supporting people to attain, keep or improve skills and functioning for daily living. This contrasts with rehabilitation, which is a process of regaining skills that may have been lost or compromised. We chose to focus on habilitation in our use of language, as we believed that many autistic offenders will not have had the support that they needed to develop the social or practical skills that they needed for effective daily living. Our recommendations were about habilitation in the community, habilitation units and prison. As with everything that I've talked about, you can find out more in the review's final report. Please feel free to put questions to the conference organisers. Scotland's independent review of learning disability and autism in the Mental Health Act has ended, but Scottish Government now has the opportunity to consider and implement recommendations from the review. There is a wider review going on just now which you can contribute to. This is the Scottish Mental Health Law Review. That review is focusing on the rights of all people who may be subject to Scotland's mental health law, incapacity or adult support and protection legislation. That report also has a focus on removing barriers to those caring for people's health and welfare. The website for that review is mentalhealthlawreview.scot. That's mentalhealthlawreview.scot. Thank you for listening.